And debate number 2 is as far as the 3 new criminal laws are concerned. The Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Sakshya Adhiniyam, which have come into effect from today. These laws have replaced the British-era Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act. Some key highlights of new criminal laws are that the summons are through electronic modes, there's mandatory videographing of crime scenes, the registration of police complaints is online, and 0 FIRs as well. Under the new legislation, victims will receive a complimentary copy of the FIR, guaranteeing their involvement in legal proceedings. Home Minister Amit Shah lauded the new laws and rubbished opposition's charge that the new criminal laws were not debated and that they were passed after suspending more than 150 opposition MPs. Shah said about 30 hours of discussion were done and 34 members participated in it. Listen it.
लोक सभा में कुल मिलाकर 9 घंटा और 29 मिनट चर्चा हुई है। 34 सदस्यों ने इसके अंदर पार्टिसिपेट किया है। राज्यसभा में 6 घंटा और 70 मिनट चर्चा हुई, 40 सदस्यों ने पार्टिसिपेट किया है। एक ये भी झूठ चलाया जा रहा है कि सबको बाल निकालने के बाद ये बिल लाया गया। बिल बिजनेस एडवाइजरी कमेटी में पहले से निश्चित था। मेरा ये स्पष्ट मानना है कि 14 तारीख से ही विपक्ष ने सदन का बहिष्कार करने जैसी हरकतें करी थी और शायद वो हिस्सा लेना नहीं चाहते थे।
Remember, the opposition has been claiming that the new laws were bulldozed by the government and passed without discussion last year when more than 150 opposition MPs were suspended. Listen in.
On the day this was being taken up, this debate in Rajya Sabha, I was the lead speaker and my speech was aborted because of the en masse suspension a few days earlier. When I had done the research, I had found that this is nothing but the manifestation of vanity to leave your imprint. Unfortunately, what has happened is cosmetic changes, 90% remaining the same, numbers changed, a few words changed here and there, and then re-inaugurated as the new central vista, the new set of laws by this government.
Majority of the members were suspended and they had no opportunity to scrutinize the bill. You would recollect that the former Chief Justice of India has said that bill, unless it is being debated in the houses, how the court will know what the legislature thought about this bill. So therefore, fundamentally, there is a problem in this bill becoming an act, because none of the members were allowed to, test this bill, talk about this bill, and hurriedly it was passed.
And what are these criminal amendment laws? What exactly are we looking at? Because from midnight last night or early morning today, these laws have come into effect. Some of the key features are that this is, of course, a huge, long-pending reform. It's actually a massive overhaul of these colonial-era codes that have now been done away with. Death penalty has been given for rape or gang rape of a minor. Punishment for mob lynching has been incorporated for the very first time. This has also introduced offence of abetment of a crime outside of India. There's also a stronger law on proclaimed offenders and absconders as well. Community service has been introduced as a punishment, which is reformatory, of course, in nature. There's also organized crime that has been brought in a separate class of offences. This is as far as this particular law is concerned. There are some objections, however, that are being made to this bill. The first is that the Bharatiya Nyaya Sanhita endangers civil liberties. The second is that the bill expands the limit of police custody under criminal law to 90 days. The third objection is that there are widely worded provisions on sovereignty and misleading and vague as well as ambiguous definitions or aspects or interpretations that are possible. There's also a lack of clarity about the applicability of terror offences, given that there is a definition under the new BNS as well as under the UAPA Act that already exists. The fifth objection is that there's no provision to punish non-consensual gay sex. Let's listen to some of the legal experts weighing in on this.
I personally feel that this is a harebrained exercise undertaken in a half-baked manner and is heedless to fundamental principles of rule of law. What rule of law mandates and stipulates is predictability, certainty and transparency. And all three are violated by these laws.
For bringing in any law, it is always necessary to have the largest possible consideration, and it is important to bring in views of different disparate people and disparate groups which are concerned with the working of the law. Having said that, Parliament has passed the law. It is to be implemented on 1st of July. I would say about 80% of the jurisprudence that exists for the last 150 or so years in India, and of course English law, that will continue to be binding and relevant. There will be no change. Some terms ought to have been defined. They have not been defined, and they will either require judicial intervention, interpretation, or legislative intervention.
You're watching the News Hour at 10, debate number 2 on Times Now, Super Prime Time.
And for more on this, let's go across to our guest. Joining us live is Justice S.N. Dhingra, retired judge of the Delhi High Court. We also have Pinky Anand, former ASG, joining us. Sanjay Hegde is a senior advocate joining us on the show. Also is Yashowardhan Azad, former IPS officer. Let me start with you first, Justice Dhingra. One of the criticisms is in this new set of laws that are, of course, in effect from 12 o'clock early this morning, or midnight last night, whichever way you put it, is that the custody that is granted to the police has been extended by a large number of days. It was earlier 15, and in this particular case up to 60 to even 90 in some cases is the police custody duration that has been increased, leading to concerns relating to civil liberties and whether the police powers that have been given are excessive. Where do you stand on this, sir?
You see, if you want to criticize a law, you can find out ways and means. This custody police has to go to the judge, to the magistrate. Please give me the custody of this man for longer days. It is the magistrate who decides that how much custody is to be given. If the magistrate considers that custody, the investigation and interrogation for which the time given to the police was not sufficient and it needs to be extended, then only he will extend. I give you an example. There was a case of Mr. Ajmani. There was 15 days custody given to the police, and on the way he reported that I am sick, I have suffered this, and he was admitted to AIIMS hospital. For 15 days he remained admitted in AIIMS hospital, and thereafter the judge said, the police again went to judge, and judge said, granted custody not counting those 15 days. High Court also agreed that those 15 days are not to be counted. But he went to Supreme Court, and Supreme Court says no, 15 days means 15 days. Right from the date of arrest, whether he remains in hospital or he remains anywhere else. So those 15 days he spent in hospital.
Okay.
And judge was helpless. I think that judge must be given discretion to extend the custody of the accused.
Okay.
In such cases where the investigation requires that custody to be extended. It is not the power given to the police. It is the power given to the judge.
Okay, sir. Let me get in a counter view on that. Sanjay Hegde, do you agree with what Justice Dhingra is saying? Because he says that it's a power that is given to the judge. There is a safeguard. It's not that police have been given these excessive powers. Do you agree with him?
Has the judiciary not granted a remand when the police have sought it? The police have sought for a week. At best, the judge says, okay, we'll give you five days initially, then we will see. So the point is, how many cases are there where you need more than 15 days remand? Most cases are sorted out within the first week. The idea that people can be indefinitely sent to the tender mercies of the police for an infinite period of 90 days, and those 90 days also do not come consecutively. It is not as if on the first day of the investigation, day one starts and that it will be 90 days. These 90 days can be over a period of time which is rather indefinite. And as long as there is the threat of police remand, being asked for at any point of time. Courts are reluctant to grant bail. So if a policeman were to arrest you and say, no, look, this is something which can have a life sentence. There are very many overbroad sections. Economic terrorism, for instance. You do a story, Madhav, on the Hindenburg episode, and somebody doesn't like it. Some policeman somewhere in the 800 police districts of India, somewhere in Madhya Pradesh says, okay, this is economic terrorism against India's economic interests. And he says, okay, come in. I want custody. And that custody can go on indefinitely while your lawyers fight anywhere in India, trying to keep you out of police custody. That is not an adequate safeguard, especially because there are several judgments of the Supreme Court saying that magistrates should not remand people in a routine fashion. Once police say have the right to take remand for 90 days, I don't see the minimal oversight from a magistrate as being an adequate safeguard.
Okay. Let me bring in Pinky Anand on that. Pinky Anand, of course, you heard what Sanjay has said, but I also want to bring in some of the criticism that what is the definition? There is, of course, organized crime that has been brought in for the first time. Perhaps that's welcome. But the point is that what is petty organized crime has been criticized by some as being too vague, and there also is a potential for that to be misused, is what some have observed. How do you respond to that, Pinky Anand?
See, I'll be honest, this kind of criticism, I think that Justice Digra was talking about ultimately. When new laws come into being, we do have this tradition of basically criticizing it. And definitely analysis is required, I don't dispute that. But on one front first, before I respond to your last question, what Sanjay Hegde was talking about, the question of remand and it being an automatic grant in the normal course of time. I think even recently, Sanjay, we've had the judgment in Purkashta, where Justice Mehta and Justice Gavai have held in terms that remand cannot be mechanical, and if it is not properly done, it must be quashed. And that's the way that the freedom of an individual is considered. So by and large, to say that police ask and is granted, and or the fact that police will complete the investigation in 1 week's time, I have not seen a case in which investigation is completed within the period of 1 week or 2 weeks. Unfortunately, that is not the case. So in any case, I mean, basically the principle of it being that you have to allow the magistrate to decide whether it should be done. What we, of course, must do is to ensure that the magistrate exercises their mind in a proper fashion and not in a technical or mechanical fashion, and let the whole issue go because the police ask for a demand. Having said that, on the front of the question that you asked me regarding petty organized crimes, I mean, ultimately, I must mention to you that the reason organized crime has been brought in is because it does need to come within the purview of crime, and it was lacking in definition. When you bring in petty organized crime again, definitions have been given in, maybe some more could be done, and that will develop over the course of time. But simply because it is not fully defined, you can't. Petty organized crime, for example, would include several facets, and it may not be possible to define. Sometimes you have to give subjectivity into a situation and then put it into perspective, which happens particularly with petty organized crime.
Okay, let me bring in Yashowardhan Azad. Mr. Azad, one of the aspects that the government has repeatedly talked about is that, these basic laws, were written in the 1860s and 70s, the IPC, the CRPC. It's over a century and a half. They were in the colonial era. And several aspects of this include, using modern technology, modern tools, for instance, videographing, audio and video recording of every arrest. Now, that is something that perhaps has to be seen as welcome and also in tune with the times. So, can this attempt at, reviewing the laws be dismissed outright in that sense?
Well, technology is welcome, and technology has its own issues. The question is, if you put jet technology on a bullock cart, can it absorb it? That's the most important problem. We have 800 districts in the country. And you have forensic science mapping and collecting evidence of serious crimes. It's a most welcome step. Should have been done a couple of years back. But we don't have the technology at all. We don't have the infra. We don't have, the states are not, spending any money on the police. And how much you can do on the modernization program. So what I'm saying is that before you introduce this, Technology absorption is a great thing. You should have given time for the acceptability of it. And also there are many other things which needed to be seen. For example, you're talking about the change in the prosecution system. There is the change in the prosecution system. If, for example, in a particular case, you have somebody like Pinky Anand fighting from the other side, and I have my same APP from this side, where do we stand? Therefore, the institutions, along with this reform, we needed a police internal reform, we needed a prosecution reform, we needed a prison reform, etc.
Right.
That is the most important point when we discuss about the criminal laws.
Right. Let me bring in Justice Digra on that. You agree with Mr. Azad when he says that it's like putting jet technology on a bullock cart because our infrastructure, our systems are perhaps not geared up to take this kind of a reform. Mr. P. Chidambaram, who is a former Union Home Minister, has today also said that 90 to 99% of the new laws are a cut, copy and paste job. How do you look at this, sir? Justice Digra.
You see, I think if you are expecting a revolution in judiciary by these three laws, you are expecting something very wrong. These three laws have only amended the old colonial laws which were in vogue in this country. Judiciary and overall system needs larger reforms. And for that, a courage is needed in the executive and parliament, which courage has been lacking right from the day of independence. We have made our whole system subservient to the advocates and few judges. You see, the system, in 1971, we made a provision that busyness of advocate would not be a ground for adjournment. This is a very simple provision. But what happened to this? In every court, right from High Court, Supreme Court and trial courts, busyness of the advocate is a ground for adjournment till date, despite law being there. Law cannot work of its own. It has to be made work by the stakeholders. And the biggest stakeholders are advocates and judges. If they don't want to implement a law, nobody can, succeed. No amendment can succeed in reforming the system. If the system was to be reformed, it could have been reformed by judges and advocates right in the beginning. We do not, deliver judgment in the language of the people. The person whose case is there, he doesn't understand what the advocate is speaking and what judge is speaking. And we are talking of putting jet in the bullock cart. I think you can criticize anything by raising anything. Justice delayed is justice denied. If you decide earlier, quickly, justice hurried is justice buried. This is how the things are happening in this country.
True.
Heaven is not going to fall if adjournments are given. So keep on dragging this system.
True.
And keep on punishing the people of this country so long as you can. This is what is happening. We are actually punishing the people of this country for not rising up against the judiciary and advocates.
Right. I want Sanjay Hegde to weigh in on that. Sanjay Hegde, do you agree with Justice Dhingra that the system and the provisions are not being followed in letter and spirit, particularly by advocates? He's talked about, the large number of adjournments, which pretty much any common man would say appears to be the biggest reason why the justice delivery system in India is so slow. And also there's an aspect that I would like you to respond in, because the Chief Justice of India himself has come out and praised these three new criminal laws as something that has been long pending. Sanjay.
Well, the Chief Justice was addressing a public meeting and he was speaking about certain portions of the law. It is not as if every particular section had come up for a judicial pronouncement after a careful evaluation. That can't be taken as a judgment on the laws, right?
Okay.
The second part is responding to Justice Dhingra. Well, there are people in this country who think bulldozers are justice. There are people who think that, shooting people in the knee and saying, giving them an Aadhaar, it's giving them an Aadhaar card. There are people who think that overturning police vans and people dying suddenly is justice being brought in a hurry. And there are also people who say, mitti mein mila denge, and things happen. But do we really think that is a country that which our forefathers wanted, where the mind is without fear and the head is held high? I don't think so. If we are to live in a system of the rule of law must be clear, must follow due process, and it must be reasonably certain. Today, we have introduced a great deal of ambiguity. We have introduced a great deal of actual demonetization of civil rights.
Why do you say that?
The game has tilted more towards in favor of the policeman and less in favor of the citizens' liberties. I think that we will, if these laws are not looked at again and suitably amended, we will have problems over the coming years.
But why do you say it's an impingement of civil liberties? Very quickly, Sanjay. Apart from this arrest provision that we discussed?
90 days in police custody when a majority of crimes are sorted out within the first week or two. You can ask Mr. Azad that.
Okay.
Most crimes get sorted out.
Okay.
Now, for a few cases, to say that, we can have the power to keep everybody indefinitely in custody, that itself is problematic. Secondly, the discretion to policemen whether to register a case or not register a case, that again creates a court at the level of the policeman.
Yes. There's also, in addition to that, two more provisions where Pinky, Anand, there are talking about where the police have more powers in terms of the preliminary inquiry that has to be done in the cases mandatorily, where the offense is between 3 and 7 years. That also, of course, is something that's talked about. And also, sedition itself, while the word has been removed, the provisions are perhaps harsher and much broader in terms of what they cover under the ambit, of endangering sovereignty, unity, integrity of India. So, while sedition may not physically be there in terms of the actual word itself, the provision appears to be more stringent. Pinky, Anand.
Well, firstly, the whole idea was to keep sedition out because it was incongruous with the current times. It was part of the colonial regime and it had come in that sense because you had a foreign government. You wanted it to be protected. They wanted it to be protected. So it was to be done away with. But to say that we do not want a law which will protect the integrity and sovereignty of the nation, I think there is no two ways about that part of the story. So I mean, just to say that sedition has been done away with, a stricter version has come, we are today testing it on sovereignty and integrity. And I don't think there is any challenge to the fact that this is not only for India, all over the world we do have provisions to safeguard the security and integrity. So no two ways about that, one. And secondly, as far as, some part is concerned, which you have not really addressed or possibly asked, is the fact that look at what the acts were meant to do. They were meant to bring more speedy justice, so to try to conclude the entire trial process within the period right from the registration of the FIR or the initiation up to the decision, within a period of 3 years. There are timelines been set for everything, which is one of the essential issues that has been confounding us for all this while. Secondly, we've changed away from the punishment system or the deterrent system totally to one of reformation system, which invites itself. Thirdly, we made it more victim-friendly. The victim is involved right from day one till day last, which earlier the victim was in a way in a worse position because all we were concentrating, maybe rightly to some extent, was that the accused should get the full due process of law. But what about the victim? The right of the victim to participate, of course, subject to whatever requirements are there. And we have been hedging towards that, the change of focus of that. The clarification of each of the issues which pertains to children, for example, making the age a uniform age across board because our concentration on women and children has been integral to our process. Electronic evidence, though we talk about structure, but rest assured, during COVID times, India's success with video and other means of communication and continuing the judicial process was one of the highest in the world, better than US, better than England, and we've actually performed better. Demonetization also brought in its own fold. So yes, we do have an issue with infrastructure at times, but we do hope that we can push it forward, and the only way to push forward in a country is to ensure that you put the systems into place. Same with forensics. We've now allowed, for example, police to audio not only the arrest, but the entire investigation process through a mobile phone. Everybody does have a mobile phone. They may not be wanting to use it, but really speaking, we do have to be able to be in a position to do that. Okay. Forensic laboratory, scientific evidence. These are the need of the hour, and there's no way out. We are developing. We may not be exactly in full place, and we may need it to have been better when we started. But we started, so we better get on with it and to put the process in place. And I'm sure all of us will work towards that.
Let me bring in Mr. Yashwardhan Azad on that. Mr. Yashwardhan Azad, a lot of reforms, fugitive economic offenders, for instance, mob lynching law being brought in, several such aspects, including community service that did not exist as a form of punishment. It's more reformative in nature. So, some aspects of this which are positive, says Pinky Anand, and that is something which is the need of the hour.
Yeah, I absolutely agree. Some of them are actually positive and should have been done long time back. If you're talking about, better mapping of evidence and presentation, there was no ban on it earlier, true. A good photograph about an accident site, a videography of the accidental area, that gives you a much better picture. That's absolutely right. I agree with that.
But on sedition? Yeah.
But on sedition, I think it's bringing it back to is absolutely wrong. Sedition was thrown out. Sedition has no place in a democracy, and Supreme Court had in fact chucked it out. My other objection is that some of the definitions have already been given very, very properly in the special laws. You have the UAPA. Again, to give another definition in the criminal laws itself, it means that it gives powers to a police officer to do it without sanction, unlike the UAPA, where there is an actual proper methodology to do. Another point which I want to mention is there is a lot of confusion about this remand thing. I, as an ex-policeman, totally oppose any idea of extending the police remand, beyond 15 days. Taking 15 days remand in various periods is all right, because during investigation, you need a lot of, cross-referencing, making people meet with again in there. But 90 days is wrong. But the Home Minister himself has said the actual remand period is only 15 days. So there is a lot of confusion and ambiguity on this, and I'm sure we'll be able to sort it out.
Okay.
In the end, I would just say one thing, that definitely there are good points, but some of these draconian measures shouldn't have been brought in. And one, the colonial powers distracted the police. The government today still distrusts the police because statements before the police cannot be signed in 21st century. And in the end, in the new act, it's surprising and must be the work of the babus of the Ministry of Home Affairs. There is no mention of police commissioner system. So there is no opposition to the police commissioner system by the politicians or anybody. It's a strange thing.
Well, a lot of controversial, ambiguous parts, and perhaps in coming days, courts will have to rule on them, perhaps more clarifications of the law. Already one particular publication has been pulled up by a high court because of one misprint allegedly in one of the provisions. But I'd like to thank all of our esteemed guests for joining us. I'd like to thank Justice Dhingra, Pinky Anand, Sanjay Hegde and Yashwardhan Azad for joining us and sharing with us your valuable experience and your interpretation of how these new historic criminal amendment laws will be in operation. Thanks so much for joining us indeed.